2015 matter, we will listed on the 8th August.
Listed on? When do you want listing?
8th August.
Tuesday. You put it on 9th of August. 9th.
May I please, my lord, item 25, my lord. It has become infractuous, my lord, so I am not pressing.
25.
Yes.
Riyaz Chauhan, Senate Counsel for the appellant has submitted that the matter has become infractuous. The appeal, the case accordingly stands dismissed as infractuous. Yes.
May I please? I beg to mention item number 1, 2, and 3, my lord. My lord, here we have my lord, send our affidavit for voting, my lord. So 2 weeks time may be granted, my lord. With the consent of other side, my lord, I am praying before the panel.
Lordship, the earlier interim order may kindly continue, Lord.
Repeat
1, 2, and 3.
Understanding Council. Elementary
My lord.
Elementary Education Department submit that the affidavit in opposition has been prepared and has been sent for vetting. Accordingly, he placed for some time. Madam Goswami, you are also appearing.
Item 2.
Sri K. Mazumdar, comma, MSD Goswami. Anyone else?
Lordship, one Mr. A.M. Borvia.
And Sri A.M. Bharvia, Learned Counsel, appearing for the petitioners. In these cases, do not object the state prayer. However, it has been submitted that there is an interim order which is required to be extended. Accordingly, it is directed that the matter be listed after 2 weeks
My lord.
to enable filing of affidavit in opposition. So, a date interim order passed early to continue till the next date of this.
Lordship,
List on
subject to convenience.
hello.
Lordship, it may be on
We can have it on the 23rd of August.
27th August,
23rd.
23rd. Then, Lordship, we may be allowed also to file our
We'll see.
Lordship.
If there's a requirement, we'll
Lordship. The earlier interim order may
we
kindly
have already said. We
Obliged.
are fixing it on 23rd of August.
Lordship. The earlier interim order may kindly. Much obliged. Lordship.
May I pray for listing of my lord IA and the condonation of delay, my lord. Any day in the
Press matter. Press matter.
no press matter, my lord. Press matter means my lord already notice was issued.
Notice has been
My lord,
issued.
yes.
Have they appeared or not?
No,
They have not appeared.
no.
Will come up for orders.
Yes, my lord.
Okay, next week.
Obliged.
Have it on next Friday.
Lordship, this transfer petition may be posted on next, transfer petition may be posted on next Wednesday, my lord, for admission.
Press matter.
Admission.
Next Wednesday have fixed many matters.
Then Friday, my lord.
Is there a stay order?
My lord.
Here for the respondent.
I am for the petitioner, my lord. My lord, there are other proceeding pending, my lord, and because of this,
On Friday next.
my lord. Obliged.
May I pray, my lord? My lord, I beg to mention item 38 of
38.
Yes, my lord.
Yes. Yes.
My lord, I am appearing on behalf of my senior, Mr. Ditul Das. My lord, he is unwell today. That's why I humbly pray.
Okay, we'll have it next week.
Yes, oh, yes, my lord. Okay, my lord.
It is submitted that deed of Senate Council for the applicant applicant is unwell. List after 2 weeks.
Obliged, my lord.
May it please, Lordship, I beg to mention one MFA matter for listing for hearing, Lordship. Very old.
For hearing, it will not come up for hearing, it will come up for orders.
Okay.
Have it in the next week. We'll see whether services are complete.
May kindly
fix
fix a date, Lord.
Give a date in the next week, not after have it on Friday next. Friday.
Next Friday.
Hey, please, your
Obliged.
lordship. Lordship, I beg to mention for listing, lordship. MSc appeal. Lordship, for orders.
Here for,
I am for a petitioner, lord. For orders, my lord.
you're not for the petition, it's an appeal. Either you're for the appellant or respondent.
Appellant, lordship.
Appeal by whom? Claimant.
claimants, Lordship.
You want enhancement of the compensation.
Lordship,
Why have you filed the appeal? You want
Lordship,
enhancement?
I also filed Lordship for restoration, Lordship. Restore has not been restored till now. So matter will kindly next week, Lordship.
Okay, when is the next?
May I please,
Yes.
your lordship? Lordship, I beg to mention item number 39, 40, and 41.
Hmm.
Lordship, can it be on Thursday? We have some urgency in this matter.
Review.
Yes, my lord. We are for the contempt petition, but respondent authority filed review petition. We
Thursday.
have some urgency.
Okay. Try and Thursday.
Next Friday.
Try Thursday.
Thursday, my lord.
Yes.
Oblige, ma'am. May it
Uh,
please. May it please.
Let us pass the order.
Yes.
A prayer has been made on behalf of the
Contempt petition.
Petitioners.
Contempt petition.
in the contempt case for accommodation. Full stop. Sarah, you have taken the consent of the other side?
No, actually, my lord, as your lordship said that today only urgent matters will be taken up.
No,
That's
but
why.
without consent, we will not pass. Not. You think that consent, you are fixing a date, without consent, will not fix the date. Government is there, who's for the government?
Yes. The government, item number 39, 40, 41.
And in
Need to be
the
on.
40 and 41, DNAT is appearing, you have to take, these are contempt matters. You have to take his consent. We will pass the order, take his
Yes.
consent.
Oblige, ma'am.
Sir, I am for item number 41 in contempt matter. I have no objection, Lordship.
41,
41.
you are for whom?
Contempt number
BP for-
VP Bora, Lordship. I am
No, he's for whom?
Rina Paul, Lordship.
Is for another.
No, Mr. Nath is also there. D Kalita, D Nath, they are there. You take the
Yes, ma'am.
consent,
Yes,
it will accommodate us.
Oblige.
Hey, it has relative to the difficult to us. After we have to order. No?
May it please your lordship, I would like to mention item number 30, lordship.
30. 30.
30, lordship. Matter may not be taken up today
Okay.
as Mr. Endega is appearing.
30. Please before any other bench without me.
Obliged.
Mayor Lordship, well, item 31.
Yes.
And the condemnation matters are there, substitution matters are there since long, those cases are pending. So condemnation as well as substitution may be allowed. Long pending case, it's a 2012 case.
I have to hear you only after hearing.
When the matter is changed.
No, we cannot allow condemnation without hearing the other side.
The other sides are since long time they are absent.
No, we have to take up the matter without taking up. How can
No,
we-
that is true, but your lordship is taking today or
We cannot say. We have to rise at it. Only urgent matter.
then that may be fixed on Friday, on Monday, Tuesday or
Okay, we'll have this one. Tuesday. Have you informed Mr. Garudia?
Garadia, that's but opposite party lawyer is not coming. Names are there, but he does not come.
We'll pass orders before rising. At this stage, if we pass orders, it will not look good without his consent. If nobody is present before we rise, we'll pass the order. Tuesday,
Tuesday.
not now. Okay.
Please, your lordship, I beg to mention one item for listing that was last posted on 3/5/2023.
What is the matter about?
It's a CRPIO.
What is the stage?
It's for continuation of interim order.
What is the urgency? You have an interim order, don't you?
There's an urgency, my lord.
What? So Friday next. Next Friday. Yes. Today we'll take up only the urgent matters. We have to rise early because of some.
Lordship, item 7, in that case, my lord, in admission matter, it will require some time.
We'll see. We are not rising immediately. Let us see. Whatever we reach, we'll reach.
Mentioned about urgent matters only.
No, whatever we reach, we'll reach.
Good.
Muslim. Item 5. Yes, madam, what is this?
Lordship, can it be taken after some time? Matter
Yeah.
relates to transfer of petition from Principal Judge, Family Court, Kamru,
Two,
to the District Judge Sonitpur at Tejpur.
what is the proceeding about?
Lordship, there is FC case, criminal, FC case, evil case 530.
What is the proceeding about? What is the case about before the family court?
Lordship is under section 13 divorce case is
Who has
going
filed?
on between the
Who has filed?
husband has filed the case, Lordship.
Husband has filed the case here.
No, Lordship, wife has filed the case here, and the husband wants to transfer it from here to Tejpur. As there is a similar matter which is also filed against the husband by the wife.
This one married with. Hello, one married with. You're the husband.
Yes, Lordship.
Wife has instituted a divorce proceeding at
Yes,
Guwahati.
yes,
You
Lordship.
want transfer of the proceeding from Guwahati to Sonitpur.
Yes,
What
Lordship.
are your grounds?
Lordship, ground is that she actually resides in Tejpur. Plus, we also have a child who studies in Kendriya Vidyalaya Tejpur. And apart from that, one maintenance case has also been filed against me, and against which we have the order and notice has been also issued on the same matter.
Maintenance case has been filed where?
Here, Lordship, family. Family court.
The maintenance case is also filed here. What are your grounds? How can you make out some grounds?
Ground is that, Lordship, my salary is only 10,000. Plus, we have one child who is studying there.
What is the age of the child?
He's studying in class 2.
What's Where is the wife residing now, presently?
Presently, she is in Guwahati.
So there's cause of action here, jurisdiction lies here. You are the husband. Unless you make out some grounds, transfer cannot be done with a matter of routine.
Lordship, there is similar matter against me, against which notice has been issued. Yes, yesterday. That matter was listed yesterday, which was transfer criminal 23 of 2023.
Regarding the criminal.
Regarding, yes, Lordship.
125 proceeding.
Sorry.
Regarding the 125 proceeding.
Yes, Lordship.
What has happened? What order has been passed by the court?
Notice was issued in that matter, Lordship.
No stay. No stay.
Yes, Lordship, there was a stay.
Let's see. Let's see a copy of the order.
Lordship, right now I don't have, but we have applied for that order, but since it was not signed, so we couldn't get the order. Yesterday we did apply. Lordship, can be taken up at 2 p.m. so that we can bring that order.
2 p.m. will not be.
At least after some time so that we can bring the order. Because we have applied.
Order passed by which court?
Justice A.D. Chaudhary.
Have it after some time?
Okay, Lordship. Obliged.
Otherwise, we'll have it on Monday.
Lordship, at 2 p.m. is it possible?
2 p.m. is not possible. We have to go to the doctor.
After some time, okay, Lordship. Okay, sometime.
After some time, but before we rise, make a mention, then it fix on Monday.
Okay, Lord.
Try to bring the order.
Okay, Lordship.
Yes, next.
Nice.
Mr. Ali, your case. 56.
Oh, sorry. A very simple matter, Your Lordship. What happened? This PW1, I am defendant in the suit, Your Lordship.
Just a minute.
So
Petitioner is the defendant.
Lordship,
Petitioner is the defendant.
I am defendant, Your Lordship. So
Yes.
we file written statement plus objection against the injunction petition. The written statement, Your Lordship, we have taken
Suit for injunction.
suit for specific performance of contract, Your Lordship. Suit for specific performance of contract, permanent injunction and possession, Your Lordship. So in that, Your Lordship, in our written statement, we have specifically stated in so many paragraphs, Your Lordship, that the agreement which has been entered into, it was obtained by fraud. And the addendum which has been added to the agreement for sale, Your Lordship, that is also, it is by means of fraudulent. Fraudulent means, Your Lordship, it was obtained by pre-existing signature on some papers, because we are friends, Your Lordship. This plaintiff and defendant are friends at one point of time. Now they are
Okay.
not. Now, Your Lordship, after exchange of the written statement and other papers, Your Lordship, it was fixed for recording of evidence of PW1. So PW1 submitted evidence, Your Lordship, and the counsel for the defendant cross-examined. Now, during the pendency of the suit, Your Lordship, the plaintiff got involved in so many cases, criminal cases. CID, Enforcement Directorate, Your Lordship, their criminal cases. He was arrested also. He was arrested also, Your Lordship will find, and we have two documents we have annexed, Annexure C and Annexure D. So when the counsel for the defendant also wanted to cross-examination on those criminal matters, Your Lordship, the advocate, Your Lordship, he said, no, these questions cannot be put. So in the similar tune, Your Lordship, he also said that I will not answer. So then he replied further, Your Lordship, this PW1, that if there is court's order, then I will answer to those questions. So the matter end here, and we file petition before the court, Your Lordship, that under section 146 of the Evidence Act, under section 46 of the Evidence Act,
Okay.
under section 146 and the Evidence Act, Your Lordship, that we are entitled to cross-examination on those matters. There's no 146.
Yes.
That's it, got it. Questions lawful in cross-examination. When a witness is cross-examined, he may, in addition to the questions herein before referred to, be asked any question which tend
Yes.
to test his veracity, to discover who he is and what is his position in life, or to check his credit by injuring his character. Already answer to such questions might tend directly or indirectly to criminate him, or might expose or tend to directly or indirectly to expose him to a penalty for or forfeiture. So this is the right given to the other side, adversary advocate, Your Lordship, that or the party, that it can be, these things can be put. Now Your Lordship will come to section 132, Your Lordship. Section 132 here. Witness not excused from answering on the ground that answer will criminate him. Lord, got it, your lordship. A witness shall not be excused from answering any question as to any matter relevant to the matter in issue in any suit or in any civil or criminal proceedings upon the ground that the answer to such questions will criminate or may tend directly or indirectly to criminate such witness, or that it will expose or tend to expose or indirectly or to expose such witness to a penalty or forfeiture of any kind. So this 132, your lordship, if it is jointly read with section 146, it is crystal clear, your lordship, that right of cross-examination on the parasitic, on the personal life and his present life, your lordship, all these things are relevant. Now your lordship come to section 147, your lordship. Your lordship.
Yes, please.
When witness to be compelled to answer, if any such questions relate to a matter relevant to the suit or proceeding, the provisions of section 132 shall apply thereto. So if it is relevant. Now, issue has been framed, your lordship, that whether the agreement for sale and the addendum are illegal. Illegal means you also have fraud or so many things. At this stage, your lordship, my only prayer when petition was filed before the trial court says that these questions are not relevant. You cannot put questions. These are criminal matters and these are not the subject matter of this suit. That is, your lordship, is necessary that he is a fraudmaster in personal life also, because he caused your lordship by defalcation, your lordship, in the state of Assam Excise Department, 1920 crores and 96 lakhs, your lordship. In another case, your lordship, involvement of 40 crores, your lordship, in Excise Department. And gentlemen, your lordship, that is known to all in Assam. So he is actually, his only profession is, your lordship, fraud. So on that count, your lordship, so these questions are relevant because he has cheated me also by fraudulent means. He obtained the agreement for sale as well as the addendum. Now, at this system, my only simple prayer, your lordship, matter may be disposed of at the admission stage itself, your lordship. And the other side, it appears, your lordship, and it may be disposed of, and in the meantime, your lordship, further proceeding in before the trial court may be instead till the disposal of this matter. That will do, your lordship, I think, at this stage.
What is the meaning of criminate?
Lordship.
Criminate. What is the meaning of the expression criminate?
Criminate. Your lordship, supposing he says something, and there will be some admission, and against on that admission, your lordship, some criminal proceeding can be drawn up.
Exactly. He can be implicated in a criminal case. But here a criminal case has already been initiated against him. And you come to the proviso to 132.
To section, your lordship.
Section 132, proviso.
132.
Yes. You have read 132, witnesses not excused from answering on ground that the answer will criminate. But come to the proviso. Provided that
no such answer which
a
a
witness shall
be compelled to give shall subject him to any arrest, prosecution, or provided against him in any criminal proceeding except a prosecution for giving false evidence by such answer. So this helps him.
Yes, and in the substantive part also, this
It helps in that.
Can you read the last part? Such question will criminate or may tend directly or indirectly to criminate such witness, and that it will expose or tend directly or indirectly to expose such witness to a penalty of what? Forfeiture or of any kind.
Lordship. Now he is saved by this provision. So he can very well answer, your lordship. And those facts, your lordship.
But what is the fault of the
it is not a new fact.
Let us see the order.
Lordship, order.
Let us see the order of the learned court.
Order, your lordship, at place. So he is saved. That is why, your lordship, he can very well answer.
No. What is the infirmity error in the learned court order? at page 73, 14.6.
73, your lordship.
Yes.
From the beginning, your lordship.
Yes, yes.
Today's fixed showing term necessary for order on petition number filed by the defendant under section 151 CPC. Filed petition number dated 14/7/22. The cross-examination of petition was almost complete except few questions to be put on the veracity, the position of PW1 in life and to check his credit, etc. as contempt under section 146 of the Evidence Act. When the question wanted to be put in respect of dispute case number 163314 under such and such sections and case number 54 registered by the CID under section such and his arrest on 5/1/2206 and in the year 2018 and regarding range in his office on such and such, the PW1 refused to answer the questions on the aforesaid matters. PW1 further insisted that unless the court's order to put these questions to the defendant side, he would not answer those questions at any cost. It is further stated in that those questions are very much relevant and same would throw light upon the entire case under section 132 and 140 of the Evidence Act. The PW1 is bound to answer the questions and there cannot be any excuse as expressed by the PW1. OP plaintiff filed written objection stating that the petition is not integral and not supported by any evidence. It is further stated that 14/7/22, the plaintiff was put to questions which are not related to the subject matter of this case. And as such, plaintiff refused to answer such questions. That case 54/15.
Mr. Ali, we have read this in your written statement. In your written statement, where is the pleadings regarding the fraud part? Regarding the fraudulent activities, both in the addendum as well as in the agreement.
In my
Written statement.
WS,
WS.
Your Lordship.
Your WS starts at
Your Lordship will come.
31.
Para 12, the para 18, page 12 of the WS, Your Lordship.
WS starts at page 31, isn't it?
Your Lordship,
It starts at page 31.
page 12, para 18.
Page 12. Well, is this petition of the WS? It starts at 31. WS from counterclaim. Isn't it page 31? Isn't it page 31?
Lordship, 1 minute, sir.
Annexure B, page 31. Madam, kindly help your senior.
WS, Your Lordship.
Page 31 of this petition.
Page 31, Your Lordship.
Yes, isn't it? I think 31 annexure B is the WS.
Yes, your lordship.
See, you are the defendant, aren't you? This suit is for specific performance, and your defense is that the agreement was vitiated by fraud.
Lordship.
Where is this statement in the WS?
That is why, Your Lordship. I'm searching, Your Lordship. It is there. Let me. Huh? Para 19, na? Para 19 of WS. Sensibly, then, not to 9.
If you have it on Monday, then it will take some time.
Para 19, Your Lordship.
Yes.
The statement made in para number even of the plain are matters of record and the defendant does not admit anything those seven except which are borne out of the records of the case that it is denied that in July, in July, so it came to the knowledge of the plaintiff that the defendant.
There is no averment of fraud.
Yes, this is your lordship.
There is
that
no averment of fraud.
defendant has committed a fraud upon the plaintiff as well as your lordship, that is there actually I my in 2-3 places your lordship that is there.
So why we are asking this question, Mr. Ali, is that in the discussion portion,
Para 7 your lordship will come
page
of the counter claim your lordship. Page 55 your lordship. From relation, okay. That the addendum that is change of being fraudulent. You got it, your lordship. That the addendum dated 34-2010 being fraudulent and the same having been manufactured and fabricated.
this is your counterclaim.
Yes, a counter claim because in the counter claim, your lordship, it is that the addendum that is being fraudulent, this is our case, your lordship. This is not your lordship. Your lordship, amended the plain as against that your lordship will file a written statement. In a counterclaim, your lordship wrote that the addendum that was charged of being fraudulent and the same having been manufactured and fabricated by the plaintiff is also void and minister illegal and invalid. Illegal and invalid, and the same is not binding upon the plaintiff. The plaintiff So, what we have alleged, your lordship?
See, there are two distinct issues. One is the plain filed by him, suit filed by him. That will have its own course. And one is the counterclaim. We are not on your counterclaim. We are on your defense to the suit filed by him.
Lordship, correct. One para. One para. Your lordship, para 18 is 41.
4-1.
41, your lordship.
Yes.
The statements made in paragraph 9 of the plain are totally false, baseless, and motivated, and as such denied by the defendant. The so-called addendum to the agreement that a change of for child is a creation, fabrication,
Okay. Okay.
and manufacture of the
Okay,
plaintiff
okay,
himself
Mr.
for illegal gain and
Okay, Mr. Third, as early, for the petition who have filed this petition under. Yes, madam, why don't you take the petition? What is section 1227? What is section 227? Is there a section 227? We don't like this kind of mistakes. Article 227 of the Constitution of India. Challenging. An order dated 14/6/2023. Passed by the learned civil judge number 2, Kamrup M. Guwahati, in title suit number 371 of 2014. The petitioner is the defendant in the suit. The suit was filed for declaration of right for specific performance of contract, comma, permanent injunction and position. Full stop. The defendant has filed written statement as well as the counterclaim. And it is the specific case of the defendant that as a defense, the element of fraud and fraud was taken. Full stop. Specific pleadings were there that the addendum, that the so-called addendum to the agreement of which specific performance was sought for was fabricated. Full stop. Para. The controversy arose has arisen at the time of cross-examination of the PW1. Full stop. Para. Really, the learned counsel for the petitioner has submitted that there were a number of criminal cases of serious nature pending against the plaintiff, and therefore, in terms of section 146 of the Evidence Act, comma, questions were put to him in the cross-examination with regard to the state criminal cases. Full stop. The learned court, however, by the impugned order dated 14/6/2023, has denied and has rejected the petition number 2967/22 filed by the petitioner defendant to allow asking of such question as on the previous occasion, comma, the PW1 had refused to answer such question. Full stop. Para. The consideration for rejection by the learned court is that such questions would not be relevant, and in reference thereto, comma, section 132 of the Evidence Act has been cited. Full stop. Para. Sri Ali, the learned counsel for the petitioner, by referring to section 146 of the Evidence Act, has submitted that such questions would be lawful in cross-examination, and in this regard, comma, specific reference has been made to section 146 within bracket 3. Full stop. Para. No, para, no, correct. The learned counsel has also referred to section 132 of the Evidence Act, read with section 147, and has submitted that the rejection is not proper and the witness is compelled to answer such questions. Para. The rejection has been rejection of the request, a rejection of the prayer made by the impugned order dated 14/6/2020 is primarily on the ground that the questions are not relevant. Full stop. Prima facie, such reasoning would require a re-examination. Full stop. However, at the same time, this court cannot overlook the provision of law, more provision of law as laid down in section 146 and proviso to section 132. Full stop. The expression used in the aforesaid provision of law is that such questions may be asked which may stand directly or indirectly to criminate the witness or might expose or tend directly or indirectly to expose him to a penalty or forfeiture. Whether the witness would get the benefit of the proviso to section 132 would also be an issue which is required to be looked in the present case. Issue notice returnable on, when is the next date?
Next date to be known, na? Next date, na? That is one answer.
It is, your lordship, only last part of August, your lordship.
Returnable on, we'll have it on 1st of September.
Lordship,
1st of September,
lordship.
returnable on 1st of September. Let steps be taken for service of notice upon the sole respondent by registered post with 80 steps by Monday. Sarah, 3 early to learn counsel praise for an interim order. Sarah, considering the aforesaid facts and circumstances and the issue involved, which would require some deliberation, in the interest of justice, it is directed that further proceedings in so-and-so case before so-and-so shall remain suspended. It is, however, observed that since the suit is of the year 2014, on the appearance of the parties, an endeavor would be made to dispose of it. Yes. Make the correction, make it article.
Section दिया था।
May I please, Lord.
Item.
Lord, I'm preferring this present appeal on being aggrieved by the order dated 4/7/2023, passed by the learned civil judge in Miss case number 677 of 2023, in title suit number 400 of 2023.
Appeal motion. Yes, what is it?
My Lord, I'm preferring this present appeal on being aggrieved by an order dated 4/7/2023.
Who are you?
My Lord, I am the appellant, main petitioner over there, my Lord.
No, not petition. Plaintiff.
Plaintiff, I'm sorry, my Lord. I'm the plaintiff in that particular and petitioner in the Miss case, my Lord.
Present appellant is the plaintiff.
Plaintiff, my Lord, in the title suit.
Okay, what has happened to a suit was for?
My Lord, suit was for declaration as well as for cancellation of a, my Lord, a gift deed, which has been executed by defendant number 1 in favor of the defendant number 2, my Lord. The facts of this particular matter is,
Right, D1 to D2. Okay, then
well, the facts of this particular matter is that all these parties before this honorable court.
you had also paid for injunction.
My Lord, I have prayed for injunction, my Lord, and temporary injunction before the trial court, which was rejected, my Lord. And my Lord, the fact is that all the parties before this honorable court are related to each other, my Lord. I am the defendant number 1 is my father. The defendant number 2 is my Lord, my elder brother, and the defendant number 3 is my mother.
Now there is a suit, the suit Schedule A premises, which was originally procured by my grandfather. And after the death of my grandfather, it has devolved upon my the defendant number one, my father, and my grandmother. Subsequently, my grandmother has also expired. And now the entire suit premises is, my lord, managed and maintained by the defendant number one. So being an ancestral property, being my ancestral property, I also have a right over this particular property, my lord. But very unfortunately, the defendant number one, without procuring any or without taking my consent, has executed and give the deed in favor of my brother, that is respondent number two, before this honorable court, and has given a substantial portion of this particular property to him. On being aggrieved by that, my lord, I have come before the trial court, and I filed an application that I have a right over that particular property as well. And as he was trying to change the nature and character of that particular property by constructing a structure over it, my lord, it's a three-storied building. At the top level, he was trying to make and alter the structure. So therefore, I have prayed for ad interim injunction. My lord, my title suit has been admitted, notices has been issued, but no injunction has been granted in my favor, my lord. And on being aggrieved, I have come before this honorable court. I have also filed an application, and a separate application which has been registered as an IA. On this date, I'm not saying that my application should be, my prayers should be considered. I'm only saying that, my lord, I'm only praying for that, and some protection, at least a protection of status quo, should be maintained, over that property.
Itself is an interim injunction.
My lord.
What is this order of status quo?
My lord,
It's an
as it
interim
is, my lord.
It
I'm
is
not-
an interim injunction.
My lord.
What is the fault of the trial court?
My lord, if I may take, my lord, to page number 75.
75, yes.
This is the order passed, my lord. And there is no
75 of the
75 of my appeal, my lord. The last page, my lord.
some mistake. Not 75.
The last page of my appeal, my lord. It would be annexure number 3.
77.
I'm sorry, my lord. There's been a mistake then. But this is the order, my lord.
47.
47, my lord.
Please read.
Petitioner is represented, heard, learned counsel for the petitioner. Peruse the petition number so and so filed under order 39 rule 1 and 2, read with section 151 of the CPC, and also gone through the annexures document. Upon careful analysis of the above observations and going through the provision of the law, I am of the view that it would not be just and proper to pass an order of ad interim injunction without hearing the other side, issue notice to the opposite OPs, asking them as to why the prayer for the petitioner shall not be allowed petitioner to take steps fixed on so and so. Without making any observations, why I should not be considered, why no order of status quo or any other order ad interim injunction should be passed. This particular order has been passed, my lord.
Only note, it has not been rejected.
But it has not been rejected, my lord. But
Notices has
the
been
non-passing
issued.
of the order, my lord, itself amounts to rejection of the, my lord, ad interim injunction, my lord. Because my prayer was an ex parte ad interim injunction, my lord, which has not been considered by this honorable.
Let us see
by the trial court.
your injunction application.
My lord. It's an annexure, my lord, 4, my lord.
We can
I'll if required, I'll serve a dusty, my lord, if required.
the injunction matters. Discussion has been applied, and as an appellate court, our role is a very limited role, as you know.
My lord.
And there is no per se rejection of your prayer. It is said that it will be considered after notice is issued.
My lord, the
And
notices are
28 has been fixed. Okay, third, 3 hours also done at counsel for the appellant who has preferred this appeal. Under order 43, rule 1R, read with section 151 of the CPC, being aggrieved by an order dated 4/7/2023, passed by the learned civil judge number 1, Kamrup, within bracket N, in connection with Miss A case number 677 of 2023, arising out of TS 400 of 2020, full stop. By the state order, comma, the prayer for ex parte ad interim injunction has not been granted, and rather notices have been issued fixing 28/8/2020. Para. Admit. Para. At this stage, this court is not entitled to call for the record. Para. That steps be taken for service of notice upon the respondent by registered post with AD, as well as by user process. Steps by Monday. Let the appeal be listed for service report of the appearance of the party on on 1st of September. Right in the ISP. The connected appeal filed against the order dated 4/7/2023 passed by the learned students in Mr. Students arising out of the right to students has been admitted today. By this application, made under order 39 Road 1, 2, and 3, read with section 151 of the CP, comma, the applicants have prayed for some interim protection. Full stop. Para. Issue notice returnable on 1st of September. That step be taken for service of notice upon the opposite parties by registered post as well as by user process. Full stop. The learned counsel prays for an ad interim order. Full stop. Para. Considering the it is submitted that the property in question is an ancestral property, and therefore the defendant number 1 did not have the authority to make or give the unilateral in favor of the defendant number 2. Considering the opposite facts and circumstances, comma, this court is of the view that balance of equities would be met. View that to balance the equities, comma, and ad interim injunction may be passed by directing that no third party right be created in respect of the suit property. It is further made clear that any construction made thereupon would be subject to outcome of the suit. Yes. Yes.
My lord, what happened, my lord? My wife, we are living very happily. Suddenly she has left my house and staying in her mother's house at Tejpur. But
You should be happy. You should be happy. She is staying in Tejpur.
yes, she has filed 2 cases in the family court. One has
You-
already been
You always say that Tejpur is better than Guwahati.
my lord, I am getting a 10,000 salary. I have to pay ultimately. If she don't reside with me, where from I'll pay? Because my child is in at Tezpur school. There is a certificate issued by a school headmaster.
Now
The
what-
Vanwala, who is carrying my child, he has also given a certificate that he
What is the proceeding? Who has instituted the proceeding?
family court at Guwahati.
Who has instituted?
My wife. Divorce file has been filed.
Where?
At Guwahati family court. But she is from Tezpur. She decided at Tezpur. Even the landlord, where she stays here, was given a certificate that yes. I have annexed all documents, my kindly. Local ward
He
commission.
resides at Tezpur.
Yes. Just to harass me, my lord.
But you are you have given her address as Jalukbari.
No, that is, she has given their Jalukbari address.
No, your permanent address. Why she will?
She has given the, what is that she has given in her petition, my lord, I have given. But she is staying at Tezpur, my lord, with her parents, my lord. And my lord, the child is regularly going to Tezpur school in the van. And she is decided, I have annexed all the certificate, my lord. The certificate of the principal of the KV, my lord, Tezpur University, University campus. Then my lord, Vanwala. Then my lord, the landlord.
Child is residing with whom?
Who are Guwahati with her parent.
Child
Tezpur. Child is with her.
with her.
Tezpur.
Let us see your documents.
My lord, please come, page 10, my lord.
10.
Yes. Is the ward commissioner that she is residing in Tezpur. In the house of Kulan Bhorali.
Okay.
Then I take you, Roshi, my lord. The Kendriya Vidyalaya Tezpur principal has issued the certificate that the Tania Datto, the child of this Kanchan Datto and Mrs. Rajashri Datto, are student of class 2, section A at Tezpur University campus. Then, my lord, I take you to page 2, Jitumuni Bosha, the van in which the child is being carried to the school.
Let us see the application.
Beg your pardon?
Let us see the application file.
She has filed last month, my lord, Guwahati.
Where?
At Guwahati Family Court.
Where is the application?
I have annexed, my lord.
Page 15. Let us see.
Yes, page 15 minutes. We came to know her eldest sister is at Guwahati. And we are hopeful, my lord, it will be mutually settled, my lord.
Allegations are very serious.
And I will, if it is fact that I will face it at Tezpur District Judge Court.
Third, previously discussed General Counsel for the petitioner who has filed this petition under section 24 of the CPC, praying for transfer. Full stop. The petitioner is the husband opposite party in FC case, FC civil case number 532/2023 under section 13 of the Hindu Marriage Act 1955, which has been filed in the learned court of Principal Judge, Family Court, Roman 3, Kamrup, bracket M, one. Full stop. The para. The Business the learned counsel submits that the proceeding has been initiated with malafide intention at one, as the respondent first part is also residing at Tejpur along with their daughter, who is studying in Kendriya Vidyalaya School, Tejpur. This court has also been drawn to certain other documents, including a certificate by the court commissioner that the respondent first party is residing at Tejpur. Full stop. Para. The learned counsel further informs this court that a similar proceeding under section 125 of the CRPC was also initiated against the petition, in respect of which a transfer application was filed before this court, and this court filed an order dated 3/8/2023, while issuing notice had stayed further proceeding. Put the para. Issue notice returnable on 12/9, same date. 12/9/2020. Para. That step be taken for service of notice upon the respondent by registered post with AD in all the three addresses mentioned in the cost ID. Step by Monday. Para. The Vistas the learned counsel for the petition raised for an interim order, considering the aforesaid facts and circumstances, whereby a prima facie case is made up that the respondent first party is also residing at Tejpur, until the next date fixed, further proceeding in FT civil shall remain suspended. Give a photocopy of this.
I'll give it. A photocopy.
The Mohanton, if it takes long, today we'll have today and have some medical issues. Long matters, not we'll fix, but on Monday. Monday we'll take it up. Monday you are here?
Yes.
2 days we should be okay.
Tuesday की take me. But not Tuesday, as per your lordship's convenience, Tuesday, no problem. Tuesday was
Because this will come on the top of the list.
Yes.
Tuesday.
Huh? Tuesday की meter. Oh, winter ना. मतलब Monday, ठीक है. मतलब Tuesday I'm having
Monday, but Monday after the motion. There will be some motion.
Yes.
We'll complete the motion because this will take some time.
Yes.
As who's for the department?
Mujumdar was.
Mr. Mujumdar. Our Mujumdar was.
Mujumdar is late now.
Monday, but ask him to be here. Even yesterday we wanted to take up, but he wasn't there.
Yes.
And we had to rise early because of some medical issue.
On
But Monday ask him to be there. We are not adjourning this matter. Okay. On request, come on, raise this matter for on Monday. On which date? And an endeavor will be made to dispose of the matter.
My lord, that Monday, Mr. Mujumdar will not be able to present his court lordship. Some matter is fixed on the Meghalaya High Court lordship. So any other date.
Tuesday? Tuesday you're here?
Tuesday I'm here, my lord. Lordship will accommodate us. We'll see to it because there are few other top of the list matters in under court.
Okay. But you come, we'll take it up Tuesday.
Yes. Yes.
Or
Make
Wednesday,
sure that-
Wednesday also, if not an issue.
Wednesday. Huh? My lord, I will be having.
No, no, Tuesday then, Tuesday.
Yes.
Tuesday date.
Yes. Obliged.
Sorry, we could not take.
No, no, not at all.
My lord, we are waiting.
Maybe Your Lordship. My senior is waiting for another court. Kindly call for time.
Awaiting instruction, madam. Kindly fix another.
Is the top of the list matter, Mr. Pegu?
Yes, ma'am.
We had issued a notice on 14/6, okay. We have said that there will be no restriction on to work upon the accreditation list, which will be subject to the outcome.
Yes.
G. Pegu.
Yes.
G. Pegu, learned here for whom?
Elementary.
Learned Standing Council.
Yes.
Elementary Education Department. Submit that instructions are awaited.
Yes.
Okay. Sarah? List after 4 weeks?
Yes. Ma'am.
Yes. The brief is also heavyweight. Councils are also heavyweight.
This will take
But-
some time, but
But the court is slightly.
I'm told.
What is the case about? Yes, you're also there.
I was there. But I feel, my lord, that we should not trouble your lordship today.
No, no, what is the matter?
Matter is, my lord, preliminary decree was there. Now the final decree process is there. Some orders have been passed and the case that they have come. I am the plaintiff, there he is the defendant,
Preliminary decree not challenged.
not challenged. Preliminary decree was challenged, but that was, my lord, upheld, that was some modification by first appellate court, but subsequently it was reversed by the second appellate court. Now it has
That means
gone
it
back,
it remains.
it remains. Now is the.
After this scope, what is the scope of challenge now?
That is the question your lordship will decide.
Isn't the scope absolutely restricted?
No, court below has passed some order against me. What has happened, my lord? Issue is elsewhere. Issue is, my lord.
It is in the interlocutory stage.
No, my lord. Decree has been passed. Decree has been
Final
sent.
decree has been passed.
Yes, my lord.
No, final decree has not
Preliminary decree
passed.
has been passed.
Yes, yes, finally
Now
not
it has,
passed.
no.
But that
it
is
has-
in
it
the
has gone to the collector.
intermediate stage.
Yes, my lord, it has gone to the collector. Collector has passed some order.
Under 54.
Yes. Against that we had to come. Because I am already occupying a plot of land sold by one of the co-sharers, and this only court in the second appeal arising out of the partition suit has upheld the sale deed by virtue of which I have purchased. So my title cannot be disputed. What they are now disputing is
Unless it is challenged specifically.
in the Supreme Court, my lord. And then
No, your title.
no, my title has been upheld by the Supreme Court.
Your title was the subject
Yes,
matter of
my lord.
challenge.
Yeah. My title has been upheld by the Supreme Court in the second appeal. So there is no dispute with my title over the plot of land. What they are saying is, my lord, in the partition suit, the land from Kokrajhar, some land from Bilasipara in Dhubri are involved. What they are now saying that the plot of land which you are now occupying, you should leave it. you should go to Kokrajhar. I'll say 110 of the Assam Land Regulation says that if I am occupying a plot of land sold by one of the co-sharers, I should be given, I'll have to pay some compensation. This honorable court has said that I'll have to pay some compensation. Initially, the collector has fixed some compensation amount, but they are not agreeing. They say that no, you have to leave this.
You have a homestead house, homestead land.
No, it's a shop, a small plot of land. 10 less.
But final degree proceeding is yet to come, yet to conclude.
Your lordship is aware.
That is the final degree proceeding. And execution stage, and if the final decree is not in accordance with the preliminary decree, they have every right to come in appeal. The bar of section 97 will not come. If the final decree is not in accordance with the preliminary decree, what they want to say now.
But the proposition of law which Mr. Mazumdar has just raised, that he being a bona fide
Yes.
occupier,
Yes.
at best he'll be entitled to compensation. You cannot
Yes.
forcefully-
But
What do you say on
trial appellate court, lower appellate court had said that the land which was gifted, which was sold to him, should be excluded.
Yes.
Now the second appellate court has said that no, this should be included and some compensation has to be given.
Yes.
This should be included in the share
Yes.
in the degree. That way, my lord, the preliminary degree is there.
No,
Now
if-
the
if
final degree
if the
proceeding.
second appellate court has gone to the extent of saying that you would be entitled to compensation,
Yes.
then the matter ends there. Why? How can you reopen the matter?
No, I am not reopening.
Yeah.
But final decree proceeding is to be done. That is to be done
No,
by
what
the
is order
collector.
passed by the collector. now?
Yes, collector.
What is the order?
Collector, pursuant to the order passed by this court in the second appeal,
Yes.
initially passed an order that I will remain here. I'll have to pay a compensation of 55,000.
Now what is the
They are-
order?
I'm in position.
Now what is the impugned order now?
Now the
If-
order subsequently has been modified
By
the collector,
no saying what?
saying that no, the partition has to take place, taking
No.
the land of Kokrajhar also. Well, purpose is when the respondents, what they want is, I should vacate this and I should go to Kokrajhar, and whereas land in Kokrajhar is traceless.
Page.
Nobody knows. Lordship, may kindly have a look at page 75 once. I'll just show one paragraph from the second appeal. One paragraph,
75.
page 75.
Page. People order page. Page input order.
Yes, please.
Yes, Lordship may kindly see.
Yes.
From paragraph 2. The second appeal is disposed of with a direction that,
Now let us see the impugned order.
Madam, before I come to the implement, Lordship will permit me just to read
Yes,
one paragraph from
Appellate
here.
court was asked.
The
Yes.
second appeal is disposed of with a direction that the sale made by the widow in favor of the respondents in the appeal is a valid sale. So in my favor, the sale is valid.
Last
As the widow, when sold their property, did not exceed their share. That was their objection, that she has exceeded. Whether the respondents shall get the property in partition or not, that will be subject matter of partition suit. They may get the property in the partition suit by paying necessary compensation. That may be determined by the partition court. The property as mentioned above will be confined to the property as mentioned in the schedule of the plain. The finding of the appellate court that the property covered by so-and-so purchased by the defendant appellant from the defendant number 1 and 2 shall not be covered by partition as found by the additional district judge is set aside. The partition court may make necessary adjustment as deemed fit and proper. Now, this adjustment, this honorable court has indicated, is in terms of 110 of the regulation, my lord. I'm just reading the regulation
Yes,
for the moment. Your lordship is aware of that. Still, my lord, I'm reading for my need, my lord. Lordship,
Come to the impugned order now.
yes, yes.
Input order কোথায়? 159, my lord, the SO's order was not accepted and directed the ASO Bilashipala to make the partition of the dictator land as per decree and submit a report. Page 159. After which the final decree will be done. And final decree is to be executed.
My lord, that is not the law. With all respect, my lord. In a partition suit of this nature, there is no, Supreme Court says there is no necessity of making a final decree. After the preliminary decree is passed, it goes to the collector. Collector distributes the land. Thereafter, a final decree is not required to be passed. I'll show you judgment of the Supreme Court. It's not, that is the end of the matter. If anybody says there has to be change in the share, the Supreme Court says there can be more than one preliminary decree. Again, there will be a preliminary decree if necessary. So this is not that case. Here, when the share has been determined, the sale by virtue. My lord,
What is the decision?
there are more than one. My lord?
Yes.
Well, unfortunately, he is the client. I told him not to sit by my side, but he is so
He
excited.
should not be in the room itself.
Yes, I told him.
But he can be in the room
But it's very
without the
difficult.
band.
I cannot
He should
prevent
not be in
him.
the court premises.
I cannot prevent him. I cannot prevent his brother from sometimes calling me and saying something has happened. I'll have to come to you, but I cannot talk over phone. I said, what is there? No, there is some urgency. They have discussed in the tea stall that they have won the case.
Because
I am dealing with this kind of client.
conversation is in vernacular or English language.
Well,
It should be in English language. The task is there.
my lord, my lord.
Let us see what is the
My lord,
judgment.
yes. Yes. No. Well, this judgment, I'll just give you the judgment during the course of the day, today. This
We
judgment is not that judgment.
English lawyer not being able to take out judgment.
My lord?
English lawyer not being able to take out
No.
judgment. English lawyer
He brought
with British accent.
what your lordship is indicating, my lord, I have also understood, my lord. And this is
We are not indicating. We are being very specific. With
My
no
lord.
indication.
my lord must have, when your lordship was on this side, noticed his car.
We have.
Well,
Remember,
so I'm very scared of him actually, my lord.
not only cars, there are many other things. And he is proud of those.
Yes, my lord. I'm also proud of him. And the visiting card also one must see, my lord.
Yes.
So with all this, I'm otherwise, my lord, enriched.
Okay, let us end this now.
My lord.
Yes, tell us whenever.
My lord.
কবে করে আমার তো 24 তারিখ 25 তারিখ 24 তারিখ 22 তারিখ বিজি আছে এরপরে 25 তারিখ 25 তারিখ তো হবে না
Why this is come up for admission?
নোটিশ issue.
Possibly notice was issued
It
only.
is yet to be admitted.
Yes, my lord.
But we can, I think, have it for admission disposal.
Yes,
Tell us date convenient to
lordship
both
may
of
have
you.
it on September.
Huh?
Okay, August
আগস্টের 29
29,
or 31
31, 31, there is another slightly.
Whenever we
bigger.
say, third, three Mazumdar Learned Senior Counsel for the petitioner, assisted by Sri. Who's there? Who's with you, Mr. Mazumdar?
13.
তুমি কে আসছে তোমার
Who's with you?
No. G. Datta Lord Mayor.
Sri G. Datta. Also has Sri B.C. Das Learned Senior Counsel, assisted by
এম হোসেন
M. Hussain, whereas Sri T.R. Gogol Learned State Council has appeared for the number 3. Full stop. As agreed to by the
29
council for the parties, comma, placed on, placed on for admission,
29th August.
for admission hearing. 29.
Well.
But please give the that citation.
Today itself, my lord. After.
And don't
I'll
engage,
ensure, my lord.
don't engage him
My lord.
for doing the research.
I'll definitely ensure.
Let him live at peace.
I will tell him the anxiety of the court also. That for that also, my lord, I'll have to use my own language.
Yes,
Interim order may can't.
interim order passed to continue to the next day.
Right.
29.
20.
Is your lordship? Lordship, in this case, lordship, we have been engaged yesterday, lordship. Mr. A. Sattar will no longer appear in this case, so we will file a.
Have you filed your wakalatnama?
No, not yet,
You will
lordship,
be
so
filed.
we will file.
Mr. Ganguly, let them come. First, P. Ganguly, Leonard Counsel for the petitioner. However, M. Dekaraja.
M. Dekaraja.
M. Dekaraja, Leonard Counsel has submitted that the earlier counsel has withdrawn and she, along with her colleague, has been instructed to appear and not be filing the power shortly. When? After a week?
Can it
Please.
be on a Tuesday or Thursday, meeting? Preferably on non-motion day if possible.
Not next Tuesday. Let them file the power
Yes, after next,
list after a week.
no, the interim order passed that then.
Interim order passed to continue to the next day. What is the matter about?
This is, suit was filed, my lord, by the plaintiff, my lord, they are the plaintiff, under section 6 of the Specific Relief Act. But the dispute is around for 2 kathas of this government land, basically. And the plaintiff claimed to be earlier in possession. And there was a, as per his case, my lord, we dispossess them on a particular date, and within 6 months he filed a suit. And my lord, based on the oral and documentary evidence, whatever the plaintiff produced, my lord, the suit was allowed, and we were directed to be evicted from that land. That we have challenged. That is the case. There are several frailties, my lord, in the case that the plaintiff presented.
No appeal is maintainable.
No, my lord. Under
Section
6, subsection 3, I believe, there is no appeal. My lord.
Okay, let us see.
Lord,
Much obliged, lord. May it please lordship. Elsewhere has been received service complete. May kindly fix the matter for hearing.
MFA.
Yes, lordship.
What's your name, madam?
N. Hussain.
M. Hussain.
N.
M.
Nagaland.
N. M. N. Hussain. Leonard Counsel. For the, you are there on record. For the appellant submit that the appeal has been admitted, comma, healthier received, and therefore the matter received, and in the meantime, comma, the contesting respondents respond, they have already entered a pair. Also heard Sri H. Gupta, training council, railways, correct? Representing the railways. In view of the above, raised to release this case for hearing in its term.
Obliged.
Yes.
May please, your lordship. Lordship, service otherwise has been completed by the last order. My chance to file PW was closed, Your Lordship. I'm against that.
Yes, sir. You want to please pass out? Where is the order? 8-6.
Order, Your Lordship, there are three impugned orders,
Hmm.
16-3, 412, and 2-7-19.
Page
2-7-2019 is at page 39, Your Lordship.
39.
The last page, Your Lordship, an extra 10.
Just a You are the plaintiff.
I'm for the plaintiff, Your Lordship.
Suit for
Suit for declaration of right title interest and recovery of past possession.
what has happened?
What has happened, Your Lordship, is that wide order dated 17/6/2017, my petition for adjournment was allowed with a cost. On the very next day, my petition for adjournment, I had paid for another day on the next date, which is 28/7.
What was the stage when you had your sought amendment?
By adjournment, Your Lordship, I was to file my PW before the court
In by way of affidavit.
by way of affidavit.
Your chief was not filed till date.
It has not been filed till date.
Okay, thereafter, what has happened?
On 28/7/2017, Your Lordship, my prayer for adjournment was rejected. However, no specific direction was made in the order regarding closure of my
28/7.
28/7/2017. However, no specific direction was made therein for closure of my right to file evidence and affidavit. On the very next day, Your Lordship, 10/8/2017, on next date, the court, by its order, had opined that since my petition for adjournment was rejected, therefore it was implied that my right to file evidence and affidavit was also rejected, and the next date was fixed for filing of defendant's evidence or affidavit. Thereafter, Your
What is the
Lordship,
date?
10/8/2017, Your Lordship. Your Lordship finds that order at page number 16.
16.
16.
Suit is of the year.
Lordship, suit is of the year 2015.
Yes.
After, Your Lordship, I had filed two applications before the learned trial court, bearing numbers 1658 of 17 and 1661 of 17. One was for with a prayer to permit me to adduce my evidence, and the other was filed as an abundant caution, Your Lordship, though not necessary, 1661 under section 5 of the Limitation Act for condonation of delay. That was filed as an abundant caution, Your Lordship. Wide order dated 16/3/18, this petition, which was filed for condonation of delay, that petition was rejected. However, no specific order was passed in petition number 1658 of 2017. Therefore, it remained. It was neither rejected nor allowed. It remains as such. Thereafter, Your Lordship, I had filed an application later on, being petition number 450 of 2019. When the suit had proceeded for argument, I had brought it to the notice of the court that the said petition which I had filed for allowing me to adduce evidence was never decided. The court on that very date, that is the order, Your Lordship, page number 39, on this date, said and directed that the petition for the condonation of delay, since it was disposed of on that day, it was rejected. Therefore, the application which I had preferred for allowing, with a prayer for allowing me to adduce evidence, was also deemed to be rejected. However, if I may please, Your Lordship, the petition, Your Lordship, finds that page number 21. This petition, Your Lordship, was specifically not filed under any section or provision of law, but if it is construed to be a petition under section 151 of the CPC, Lordship, the petition for condonation of delay was mere formality. It was not required in this case. And since that was not a necessity for deciding this application, rejection of that application for condonation of delay would not automatically result in rejection of this very application wherein I had prayed for allowing me to adduce evidence.
But what you have shown are the initial orders of 28/7 and 10/8 at page 16.
Yes, Your Lordship.
See, your continuously, your conduct,
There admittedly were certain lapses, Your Lordship, that I cannot deny.
see, come to 28/7 order at page 15. In the petition, have you got?
Yes, Your Lordship, in the petition number
Now
eight,
if you have to move the petition. A petition has been filed, their advocate is preoccupied.
the advocate, which is not a valid ground for granting adjournment.
So
Yes,
seal the plaintiff, then it was granted, now no doubt it was. Say, see the second date, 10/8.
second date, Your Lordship, it was granted with cause. Second date, thereafter it was.
Second date, plaintiff side has paid for adjournment by petition, but none appear to move.
There was
Hard
CR,
clear.
her and dependent.
Petition has been filed on grounds that petition has gone to Kolkata. Suspense, so and so. Last day to speak for evidence, already been closed by necessary implication. We don't find the route to be in any infirm or any with any error. The basis of passing this, these are change of orders, and moment the learned court takes up the matter, definitely the orders are consulted.
That is
And
right.
after that, if you file an application, and obviously they will not adduce evidence, but there is no requirement. Since there was no, your evidence from your side was closed.
But they did not reduce
There
it.
is no requirement.
Your Lordship will come to the grounds which I have mentioned in my petition before the trial court, whereby I have made prayer. Therein I have stated on affidavit that I was not intimated by the local council who was there, and therefore I could not appear on that day. That is the sole ground taken on the petition. Your Lordship finds those grounds at 23 onwards.
2-3.
2-3.
What is the stage now?
Stage, Your Lordship, is at argument stage. Arguments could not be adduced.
No, that was the argument long time back. Now, presently, what is
It has been stayed thereafter, Your Lordship, after filing of the
Where is the
CRP.
stay?
It has been.
Suit is of 15.
15, 2 days of 15.
Any decision you have brought?
It's a common decision that
Fault of advocate.
fault of advocate, Your Lordship.
There's
Paragraph number 3, Your Lordship. In this case, the counsel
big case of Rafiq.
Rafiq, Your Lordship. Mary,
We have read this earlier. Allahabad case, many lawyers are there.
Yes, your lordship, many lawyers that did not appear.
Should consider judges matter.
Very
Not. Witnesses on the third. No? On the third Tuesday. We'll have it on witness.
Very well, your lordship.
Heard branch of the return counsel for the petition who submit at this court by the last order 16/6/2023 has already recorded that service is complete. Full stop. None has appeared. None has appeared. The respondents have chosen not to appear in spite of such full stop paragraph. Please for admission hearing on petition hearing on witness. Nine will take up.
Deeply,
You
your lordship.
can hand it over on the time. This may not be enough. Let us. Probably will not be sitting, there are any matters, urgent matters,
Item 54, there is an interim order till today.
54.
Yes.
Any matters are
No.
interim order till today.
Item 17, my lord, it has come for admission. The date is fixed tomorrow. It's an FA against the order of remand. The order has been passed to cross-examine the PWs in the trial court, my lord. We are challenging that order because
If I come for the first time,
yes, my lord.
now, today.
Yes.
It's good. What have you?
Similar is 19, item number 18, lordship. It is an FAO under section 37(1)(a) of the Arbitration Conciliation Act. Refusal to refer the parties for arbitration under section 8. Our application of section 8 was rejected
It is rejected by whom?
by civil judge. There is a suit filed by the,
Understood.
Lordship, I'm opposing
today is the first day. It is,
I'm opposing his prayer lordships, but I have wakalatnama only for
Doesn't matter. Why rejection of 8 is mandatory?
No, lordships, he has filed they have decided it through a reasoned order, lordships. Lordships will consider the impugned order.
anyway, this is an appeal first.
It is a recent decision. He has given his reasons for.
Are reasons
Not
sufficient? Isn't it the mandate of law? Even
Not-
the requirement of having an
Because
order.
lordships, they were not party to the arbitration petition. All of them were not party to the arbitration agreement, lordships. Therefore, the reasons.
Were you party or not?
Lordships, I have just been engaged yesterday.
Were you party in the?
Yes, I was party.
Then
But lordships, I have not been able to go through the entire documents. I've not been able to examine. And there is a.
that will happen
wakal-
on Monday. Your matter.
Monday is the day of Monday. lordship.
Monday.
No, no, Monday.
Doesn't matter. What is it? If we think that it's a case for demanding for arbitration section 8 provisions, we'll pass orders. Let her be equipped with the record with the instructions.
On Monday. lord.
Uh,
Item 18.
Lordship, can I pray for Wednesday, Lord?
Wednesday,
Monday, I think date is fixed before the talker will take.
final. How it is the forecast letter comes for whom?
For petitioners.
Who are?
Petitioners are defendant number 1 to 5, 1 to 4.
No, is it some government company? No.
No, lordship. It is
For the petitioners. Who were the defendant
defendant
in
number.
the suit? Also, the grievance is against the order by which the application made under section 8 of the Arbitration and Conciliation Act 1996 has been refused. In spite of the fact that there was an arbitration clause for resolution of any dispute within the parties. On the other hand, MSS Chakraborty, Learned Counsel, has submitted that she has just entered appearance for one of the parties.
Respondent number 2, Lord.
Respondent number 2, and would require some time to have the complete instruction. See accordingly, please for taking up this matter on any other, on any other. We list on Wednesday.
My lord, item number 20 and 21 may come up in the next week, my lord. These are the new
Dates
cases.
he'll give, for dates,
Yes.
court master will give. Only
Lordship,
matters where interim order is still today. Madam,
Lordship, I have taken the consent of Mr. Deenat in item 39, 40, 41.
Yes,
Lordship,
what do you
kindly take it on Thursday, my lord. We have some emergency.
okay. What,
Thursday.
39, 40, 41.
Yes, my lord.
A prayer, it has been, it has been submitted that there is some urgency in this matter. Please, on.
My lord, item 16, my lord. Is there urgency, my lord?
Urgency date, he'll give dates.
Monday, my lord, Monday.
Monday is not possible. Monday,
Tuesday.
what is the matter about?
Matter is regarding injunction, my lord. Against the injunction, rejection of injunction.
Fresh matter.
Fresh matter, my lord.
Fresh matter will come on Monday.
Fresh matter.
Fresh matter will come. We are not.
Obliged.
fresh matters only.
Wait, please, your lordship.
Item number 54, there is interim, is urgency is there, Lordship.
54 interim is there.
Yes, yes.
We extend it to
Lordship, regarding item 19, interim is there, lordship.
19 interim.
Hello.
Mr. Das,
Item 53, madam. There is an interim order. Let it be fixed on 29th. Along
we are
that
fixing
case.
a date, we are extending the interim.
Interim to continue.
Proceed 43, attempt number 43.
Yes.
So let it be kindly depicted on Wednesday.
Wednesday. You are an outstation counsel.
Yeah, and
If you want, we can take up your matter. You come from Naga and Dimapur, I think.
yes,
If you want, we can take up your matter, if you are prepared.
Monday, I may not be having.
No,
time.
today, now. If you want, we can we'll take up your matter. No. Who's on the other side?
Lordship, item 49.
Who's on the other side? Who's the other side counsel?
So I'm here.
Oh, you. You're ready for the matter today?
Yes, Mr. MP Sharma, sir.
Who?
MP Sharma.
Please call. Yes, madam, what is this?
Item 49, that will be fixed.
That court master will give.
Item number 32. Lordship, as the respondent number 1 is died, so kindly allow us to file substitution petition.
When did he die?
Your lordship,
What is your name?
P.
You're for the petitioner.
Yes, sir, lordship.
MSPD, Senate Council for the petitioners. Head of petitioner 1 has submitted that the respondent number 1 has passed away in the meantime, and there will be requirement to file substitution petition. He accordingly prays for and is granted 3 weeks time
Sure.
to file such. It's up to 3.
32.
What do you think? Put it on. Put it. Very well.
Proceed, this is the contempt petition proceed.
Yes, the report was given to you.
Proceed. I filed
We need a government counsel to hear. Who is for the government? Last occasion, Mr. Gogoi was there, T.R. Gogoi.
Lordship, the police has already submitted the report.
Yes, no, we had instructed furnishing of a report to
proceed, yeah,
Mr. Omai.
I received the, I mean, the police report, but that police report is given only for the regarding the construction proceed. But they are not mentioned, I mean, demolition. But the contempt, I filed a contempt in the months of, I mean, April, Lordship. So actually, the interim pass in
10/3/2023. But the respondent already started to remove, the all house, demolition and something like that on 14/3/2023. Then actually I given the annexure, C1, the page number 12.
Yeah.
This is the before, situation. This is the before situation means before, during the interim time. This is the interim time. After interim, they're removing an annexure 2. See the annexure 2 on, that is the 14/3/2023. But during the interim order, they have been removed all the demolition and such everything. But I went to the police station on before the annexure.
Let us see the order.
Rosip annexure C5.
Let us see which order you are alleging that there is contempt.
Your
there is
lordship, we have
violation.
filed affidavit in opposition to this.
Which is the order that the petitioner is alleging violation of? Is Mr. Rangmai, where is the order? Which order has been violated?
Mr. On annexure C8, case number 22, Rosik.
22.
10/3/2023. The heart, the MD coming to heart and council the appearing to application FP, the Sharma, the runner council, they appeared and the respondent. The issue notice the returnable in 4 weeks. Since Mr. FP Sharma, the land, the council, they appeared on behalf of the defamation respondent, the notice to the wife, however, the extra, the copy of the IA, the shop on the runner council appearing for the respondent within the 1 week for today. Meanwhile, the status quo has today to, in respect of the plot of land in question, be the maintained by both the party and further order those things. But before the interim order, nothing had been done. After the interim order, they started remove the all, demolition there, all the, house and something like that. Then we went to the police. Then Khatkati Thana is not accepted. Then on 18, the petitioner went to the, SDPO. The SDPO they accepted the petition and just.
Now, what is your reaction to the report? We had called for the report.
See, Rosie, the police report. It is when the government, the advocate Assam Guwahati High Court submitted the letter against the contempt the case You
have to well close this.
Rosie, with reference to
In
the
terms
subject
of
side.
the report, see, his report was called on 21/4. He also
Yes.
agreed to the report. Now, if you say that report is incorrect, you have to challenge that report. But there cannot be any contempt. But the R.A. Rangmai, Senate Council for the petitioner, also heard. Mr. Sharma would come or not?
No, he's not.
MS
BM Chetri.
PM Chitri, Learned Council for the whom? Sole respondent. Also, Sarah, the present petition has been instituted alleging violation of order dated 10/3/2020 passed by this court in IAC 621 of 2023. arising out of RSA 32 of 2023. Para. The learned counsel for the petitioner, by drawing the attention of this court to the aforesaid order dated 10/3/2023, has submitted that a direction was passed for maintaining status quo over the plot of land which was the subject matter of the litigation. It is the case of the petitioner that the order of status quo has been violated and the old house was removed and there was construction of Pakka RCC pillar on 14/3/2020. It has further been submitted that the Katkati police station was approached, whereafter all the construction was going. I must state to the letter counsel for the sole respondent has submitted that the allegation of violation is absolutely incorrect, and he has also referred to the affidavit in opposition filed on 29/5/2020, where the respondent has categorically denied the allegation of any violation. This court, while issuing notice by the order date 21/4/2023, had directed that for the interest of justice, a report be called from the officer in charge, Katkati police station, regarding the allegation of violation. In this connection, the T.R. Gogoi, the learned state counsel, has submitted that in compliance with state direction, a report has been furnished, which was already reflected in the court order dated 27/2020. After hearing the parties, this court has noted that in the order dated 27/2020, this court, after perusal of the report dated 26/2023 of the concerned officer of the Katkati PS, had come to a prima facie finding that the allegation of contempt cannot be substantiated. However, for the interest of justice, a report was directed to be directed to be furnished to the learned counsel for the petitioner to seek instruction. The learned the learned counsel for the petitioner, however, submit that the violation has been done even prior to making of the verification exercise. The submissions made on behalf of the petitioner is essentially a matter of fact. There is no challenge or dispute with the correctness of the report dated 26/2020, and the said report has been furnished pursuant to an order of this court dated 21/4/2020. It is the report categorically states that on the visit, no construction was found to be going on the disputed land. Also, it is also stated in the report that the parties were directed to maintain peace and not to create any law and order situation. A court exercise powers of contempt is required to act with due care and attention, as the consequence of contempt is penal in nature. Also, in the instant case common, no such act is found to be contemptuous in view of report dated 26/2020. In that view of the matter, the contempt is closed.
Item 17 was paid, the date is fixed tomorrow. I am challenging an order of remand by the learned past appellate court, giving an opportunity to cross-examine.
Who's for the other side?
But it has come for the first.
First time, yes. Yes, for you.
Well, the order is available at page 56, right? Order at 3723.
Just a minute. You are for petitioner is who?
Plaintiff, my lord.
Petitioner is plaintiff.
Suit for specific performance of contract.
Okay.
It was decreed in my favor.
So decreed.
Yes, my lord.
Thereafter,
the defendant went for an appeal. At the appellate stage, they filed a petition under order 41 rule 27.
additional evidence.
Yes, my lord. And on the basis of that evidence, petition, an order was passed on 3/7/23, which is available at page 56.
37/23. Page 56. This
Yes.
is the impugned order.
Yes, my lord. It is the order of remand.
56.
56 is the impugned order, my lord.
Please read.
Both the parties are represented. Date was fixed today for judgment. At the time of preparing judgment, I found that the court below dispensed with the cross-examination of DW1, as a result of which the plea of defense was not proved. Moreover, it appears from the record that White ordered 13/2/20, the adjournment was refused. The appellant stated the subsequent dates were affected by COVID-19, and the judgment was pronounced in July 2020, which was a time overshadowed by COVID-19. The appellant filed a petition bearing number so-and-so under order 41 rule 27 CPC. On perusal of record, it is found that it is a fit case to exercise the power contained in order 41 rule 27 CPC. In view of the above, I deem it fit to provide an opportunity to appellant to adduce evidence. The case is remanded back to the trial court for cross-examination DW1 and for any additional evidence in defense, if any. And the several opportunities were given to cross-examine the PW witnesses, but DW1, my lord, but they did not come up before the court for cross-examination. So lastly, the order was passed whereby the cross-examination part was closed, which is available at page 37. This order was never challenged, my lord.
Okay, how to as this was learned counsel for the petition who has filed this petition under article under
Order
this is an appeal.
Yes, order 41
Under
rule
43.
1U.
Rule 1U of the Code of Civil Procedure. File prepared. Full stop. The subject matter of this appeal is an order dated 3/7/2023. Why is it appealable?
My lord, it's an order of remand under order 23. The order was first exercised in jurisdiction under order 41 rule 23. So it's an appealable order. My lord.
But the remand was only for the purpose of adducing evidence, isn't it?
But my lord, when the remand order was made, if I may take your lordship to order 41 rule 1U, the jurisdiction under order 41 rule 23 was exercised. Was for additional evidence, my lord, there was no question for remand. The appellate court himself could have taken up the matter for additional evidence as per order 41 rule 27 and 28. You says an order under rule 23 or order 41 remanding a case where an appeal would lie from the decree of the appellate court.
What if they are you?
1U.
1U.
Yes.
3/7/2023, passed by the learned additional district judge F.C. Pachar, Silchar, by which the matter filed in title appeal number 4 of 2020, by which the case was remanded to the trial court for cross-examination of DW1 and for any additional evidence defense. Full stop. This paragraph. The petitioner was the plaintiff
Yes, my lord.
in the suit which was filed for specific purpose of contract. Full stop. The suit being decreed, comma, the aforesaid appeal was preferred by defendant as appellate, in which an application under order 41 rule 27 of was filed for exercise the powers of the appellate court to adduce, to allow the parties to adduce evidence. The business by referring to the dispute order dated 3/7/2023 has submitted that the order lacked reason and the discussion made is not with regard to the requirement of the precondition for considering an application under order 41. The further submit that in any case, instead of exercising such power, the matter has been remanded, which and remanded and according to present document. Where I had been will not calling for the record. Oh, call for the record.
The order may be stayed, my lord.
Yes, where is your application?
My lord, no separate application is filed, my lord. Order 41 rule 5 is against the decree for staying the execution.
Will not agree with.
My lord, it's a appeal against an order interlocutory order passed by the appellate court, my lord.
You have to file a miscase.
My lord, if I may take your lordship to order 41 rule 5,
We are not going into those procedural part. We are not passing an interim order in an appeal without any application.
well, order 41 rule 5, I
File an application. We have called for the record. We are inclined to pass an interim order. So without an application, we will not. Steps be taken for service of notice upon the respondent by registered post as well as usual process. the appellant is at liberty to file necessary for interim order if so advised.
Records.
File it immediately.
Yes, my lord. Records may be called for. my lord.
And don't make this kind of mistakes. Appeal after all. Why are you going into those technicalities? It's not a repetition. So call for the record.
Yes.
Yes, anything?
Me, I'm not insisting for today, Your Lordship. Item number 53. Your Lordship, there is a stay operating against us. So may I take
Against you.
against me?
We have a date.
8 or 9, 10.
He'll give a date. Not file up.
My lord,
Nine.
records of title suit would be necessary. Title suit because the matter is now pending before the
We
trial.
have call for the record. If, submit this, place this for the trial court. You'll understand.